All right, everyone, it's noon, so we'll get going here and be respectful of all of your time. Thank you all for joining me today. We're going to do this is part one of kind of partnership agreements. And today we're going to focus in on buy-sell agreements. For those of you who don't know me, I'm Stan Doida, one of the founders of Doida Crow Legal. Doida Crow Legal is a corporate boutique here in Denver, Colorado, and our mission is to serve entrepreneurs, helping them with, buying and selling companies, raising money, and growing their companies from ground up. We work with a host of entrepreneurs in different industries, and that's really kind of the critical common thread is an entrepreneur. I've been practicing law. I think this is my 18th year of practice, and I've been running and operating my own firm here for about 12 years. So I too am an entrepreneur and kind of understand the practicalities and difficulties and challenges of entrepreneurship. Today we're going to talk about agreements with partners and in particular the buy-sell agreement. Agreements with partners kind of depends on what entity you're in. For corporations, your sort of quote unquote agreements may come in a variety of different documents. One is the certificate of incorporation, which is filed with the Secretary of State, setting forth some of the rights and boundaries of shares and shareholders. Bylaws often have procedures and other agreements about how meetings, for example, have to be run, votes have to be run, how officers are appointed, how board members are can come on and off the board. But a lot of the buy-sell agreements might show up in a shareholders agreement. Likewise, in some situations you might have what are called vesting agreements where, maybe you're issued shares that are still subject to vesting. You haven't earned all of the shares yet, and that's a way to kind of keep yourself accountable or hold your partner accountable to performance there. In the LLC or partnership context, we wrap most of this up into an operating agreement or a partnership agreement, which is one of the nice features. It kind of simplifies and consolidates all of the documents, agreements, procedures into one spot. Corporations, you kind of have to follow this other framework, which is just slightly different. So what is a buy-sell agreement? A buy-sell agreement is really just an agreement between the company and or the shareholders or partners regarding the purchase and sale of their shares or units or membership interest, partnership interest, whatever it is. But it's an agreement saying, hey, if these events happen, this is how one can buy or sell their shares. Why is it important? There's a lot of stuff. I think, one of the main things that partners, when they start talking about joining forces or becoming partners or joining a company, they talk about all the kind of key foreseeable business things. How are we going to make decisions? Who owns what? And if you get kind of a quote off the shelf agreement, say from LegalZoom or some other, provider, my guess is they're going to cover some of that operational stuff. But one of the things I think it's widely overlooked is the buy-sell agreements. And frankly, that should be part of the initial considerations in partnership. So, things like, the inevitable death, permanent or significant disability or incapacity, things like bankruptcy or foreclosure. These things can create involuntary transfers of your interest. And when we say involuntary, it just means it's going to happen by operational law. If you die, all of your property goes to your estate. And, if you're married or if you have a trust or whatever it is, all that property goes to that estate or to those heirs, to that trust, and then they're sort of controlled by somebody else. So often, give an example of two partners who start a business together. They didn't necessarily sign up to say do business with that partner's spouse if their partner dies. So things like a buy-sell agreement can help plan for those events should they happen. And so again, this is to avoid unintended consequences of who can become your partner. Some of the scenarios are, your partner's spouse, your partner's kids, a trustee in bankruptcy, just a unrelated third party who becomes owner of these shares by virtue of a transfer, voluntary or involuntary. So we want to protect the company. We want to protect partners from these unintended events happening. By the way, there's a spot for you to jump in with questions. I will do my best to answer those live and on the fly, but at the very end, I will certainly take time to make sure that I address everybody's question. So, how do we structure buy sells? There's first and foremost, we're going to dive into all these things, but first and foremost, we need to figure out what are the triggering events. What's going to happen that's going to create this potential issue. Let's list those out and then figure out what to do from there. The next is what happens in those. What happens in those events? Depending on the structure, you might be able to do things like take away voting rights from a partner who has experienced one of these triggering events. So, for example, if partner A dies and partner A's spouse inherits the shares, in an LLC, we can convert those units or those shares or whatever they are into what are called economic interest. It gives that spouse the right to receive the distributive share of profits that the deceased partner would have been entitled to, but it does not give the spouse voting rights. And so there's things like that we can do. We got to consider whether these buyouts are optional or mandatory. And I think depending on who you are and what the circumstances are, the answer might change. We want this one to be optional. We want this one to be mandatory. We want them all to be optional. We got to define whose option it is. Is it going to be the company's option? Is it the other partner's option? The big issue that everybody wants to know is how is it priced? And we got to come up with either, methodologies, frameworks, or defined ways to come up with how we price these when these events happen. The other, a lot of people get stuck on the pricing and then they forget to address how it's going to get paid. Think something like somebody's death is not something the average company is building up a cash stash for, to say, hey, if my partner dies, I got the cash ready to go to buy them out. So we have to figure out practical ways that this can get paid. And then we'll talk about some hidden traps and some problems that, in practice make buy-sell agreements tough to execute. So the triggers. I think the classic triggers, we've talked about death, disability, and incapacity. And again, just to break that one down, disability might be, physical injury or ailment that is preventing you from doing the work that you once did or need to do for the partnership. And incapacity is probably the inability to even make decisions on your own. So, think about, where a situation where a conservator is being appointed to make decisions on your behalf. You may be physically able to walk around, but you're not, mentally capable of making decisions anymore. So slight distinction there. Bankruptcy, foreclosure, a judgment or a judicial order. Think about a situation where you can't settle up a divorce and the judge says, fine, I'm going to ship half of your interest in your company to your ex-spouse. That's a situation where, these shares are changing hands and we would want to address how to deal with that. Other triggers that I think, need to be considered, especially in partnerships where the partners are key laborers for the business, that they're putting in their time and energy to work for the company. I think you got to think about termination of employment. You got to, this is a whole, this ends up opening up a whole nother discussion, but you got to think about if somebody wants to leave, if somebody's not performing, if somebody's fired and they're sort of minority partner, that might be another opportunity where we say, hey, we want to address your ownership here, because just somebody getting fired or leaving the company doesn't necessarily address what they do with their ownership in the company. Buyout procedure. Yeah, again, so we want to in a good, well-tailored buy-sell agreement, we're identifying, one, whether this is optional or mandatory, and who are the parties that either have the option or the obligation to buy out shares. Is it the company? Is it the shareholders? Is it potentially both? There are tax considerations to consider. For example, when the company can buy out, or what we'd call redeem, a departing shareholder, or a deceased shareholder, something to that effect. The company can use, its money to buy out the shareholder. Alternatively, the remaining shareholders could buy them out. And that's different. You're not using company funds for that. You're using sort of post-tax personal funds to buy it out. The tax considerations there are, one, like I said, pre-tax versus post-tax dollars. But alternatively, a shareholder who buys out with their sort of post-tax dollars also gets an increase in basis in their shares. So there's lots of reasons to consider both. But again, and you can tier it too. Like we often will tier these options so that it's the company's right first. They have so many days to exercise, and they exercise through some notification and within a specific time frame. And if they don't, or they waive their right, it goes to the remaining shareholders, who all have a pro rata right to buy their percentage interest in the deceased shareholders, in our example, their shares. So you gotta go through a pretty thorough and clear way of who's right, or whose obligation is this. Next, you got to set up some notice and timing. Decide how they're going to get exercised. Is it just a written notice? Do you give it to the board? Do you give it to the shareholders, etc.? And then how long they have for all this. I think one of the most common things I see in drafting is something like a 30-day trigger. Hey, you got to exercise this right within 30 days or something like that. And I think that can be pretty tricky in some events. For example, a key shareholder's death or incapacity or disability. I've described it to some people as sort of insensitive to have a buyout procedure that's triggered and needs to be exercised within a short period of time after some catastrophic event like that. And in addition, having a short fuse like that can risk that the time passes before anybody kind of gets to it. I can tell you, having been the executor of my father's estate, it took me well over 60 days to kind of get the lay of the land. So for timing, I think there should be some consideration rather than just throwing out some numbers to get this done. Valuation and pricing. This is the big one that everybody always focuses on. I've laid out some common methodologies here. We're going to go through all of these, and I will kind of share my experiences and what I view as pros and cons. Number one is book value, and book value, I think, probably can be easily understood by kind of understanding the equity accounts of your balance sheet, right? You have assets, you have assets minus liability equals equity. If I'm a 50% holder, the book value might say that you've got 50% of that equity. The pros to that approach is that it's really easy to get that number. We'll be able to run a report through QuickBooks or whatever your accounting software is, and pull a balance sheet and say, well, here's what the equity account is. The cons to that approach are it is really a backward looking number. It's looking at all the transactions that have happened up to that date. It takes in no account of growth rates, trends. You just got that, you signed that big contract for that new client that's going to start yielding revenue in the next quarter. None of that stuff is going to get captured in a book value analysis. So, easy to get. There's a lot to say about in these situations of having ease in getting this number and cheaply. But I think, you always have to, when you evaluate these valuations, you always have to put yourself on both sides. I'm a buyer and I'm a seller. And when you're the seller, I think oftentimes you look at it as, well, it's very conceivable that I get shortchanged on the, where this company is going in terms of all the work we've done now and what we're going to realize in the future. You're not going to capture any of that in book value. Second common approach is using an equation. This is, we'll say, hey, we're going to take our EBITDA or our net profits or our revenues and, add some multiplier to it. And that will be how we value the company. Again, the pros, easy to run the numbers through an agreed upon equation. I think the cons are, I tell clients, I don't know which party is going to be dissatisfied, but I know one of them will be dissatisfied. You do things like, hey, we're going to do our multiple, our EBITDA multiplied by, 6. 6 is the multiplier. 6 is the multiplier that a company in our industry and of our size would get in a M&A transaction. Well, frankly, I think that money or that multiplier moves over time based on market conditions, things like that. So it's really tough to say that this multiple that you're using is going to be, the right multiple at the right time. And I'll tell you, I've seen some perverse outcomes. In fact, I've seen one instance where it came out negative. And I think that's, particularly bad, a bad result there. So equation, again, easy to get, probably a lot of risk on the back end. I don't recommend the equation. I can understand book value in certain contexts. The equation is one I try to steer clients away from as one that I think will be producing an outcome that at least one party is going to be very unhappy with. The stated value is this is kind of the idea that, hey, you know what? Each year we'll come to an agreement and we'll list what the value is on an exhibit to our operating agreement. And I think in theory that is great. I think in practice, of course, almost 100% of the cases that come to us, they haven't done that for an extended period of time. When you're running your business and the sun is shining and there's no problems, my guess is there isn't a lot of attention being paid by the two owners of what the value is. It only starts to become a priority for one of the partners when they've got some agenda. They've got, they want to leave. They want to They want to sell. They want to get out of this. And so, unless you're extremely diligent about doing this year in, year out, or whatever your stated cadence of agreeing to a value is, I think there's a lot of risk that too much time passes. An event happens like death, which nobody's planning for, and suddenly you've got, you guys haven't come to an agreement on a stated value in the last 4 or 5 years. Now what do we do? So again, not necessarily a practice I can endorse without, a lot of diligence and commitment behind the partners to undertake that year over year. Frankly, I think appraisal is the most fair process. It's the pros are you're going to get a fair outcome. You're going to get what a third party, based on real live then market conditions, thinks that the company can get. They're going to use multiple different methodologies to determine this. They're going to use multiple equations to get what the value is. The cons are it's time consuming and it's expensive. Usually the path that I would advise a lot of clients to take is to create a appraisal process in a dispute. So give the partners a chance, or the parties that are involved in the purchase and sale, a chance to agree on a price. And if they can't agree, then they've got a backstop to use an appraisal process. And again, the appraisal process needs to be pretty thoroughly vetted out there and fleshed out in terms of how they're chosen, who's a qualified person to do this sort of thing, how are the fees going to get paid, what happens if we can't agree on an appraiser. We need to cover all that sort of stuff. And so, the pros are, like I said, you're going to get a fair price. And the cons are that it's maybe a little painful to get there. But nonetheless, when all, I can with, I could safely recommend appraisal in almost every case because it's going to yield, quote unquote, fair value based on a professional's opinion. All right, how is it paid? So, like I said, these events, if you're mandating that a buyout has to happen, or if it's just optional and you want to trigger it, you may not have been saving cash to pay the buyout fee. So, somebody's death, I describe this as an unexpected cash bomb. If you've got a $500,000 value in interest and you suddenly die, it's without insurance or anything like that, the company may be hard pressed to write a check for $500,000 to cut you out. Maybe they are, maybe they aren't, but we got a plan for the case where they're not prepared to pay that and still need to exercise the buyout. So a lot of times we'll do some agreed upon financing terms. And so the way that looks is, let's take the case where, you got a $500,000 interest that's being bought out. It's mandated, and it's mandated, or the option is being exercised. What we'll often say is, hey, if the company or the buying party has the cash to do it and they agree to do it, they can pay all cash. If they don't, however, then we're going to set up some minimum financing terms for them. So it might look like you got to pay 20% down and then pay the rest out over the next 4 or 5 years in equal monthly, quarterly, annual installments. You might set up some security for the party that's being bought out. Hey, those interests that I just sold to you are being pledged as collateral, and if you default, I'm going to take them back. That sort of stuff. With death and permanent disability, there's an opportunity to insure against those and to use the proceeds of those policies to finance a buyout. And again, you have to You have to kind of tailor those buyouts to the insurance policy plans. And I think also you have to kind of cover for the fact of, well, what if we accidentally let these insurance policies lapse? What if the insurance policy doesn't pay out, or whatever the case is? We have to provide for some contingencies there. Yeah, so that just basically goes to the last point of structuring this, especially with insurance, is critical. Some of the hidden traps and complications in buyouts. I think the thing that complicates buyouts the most are things like loans, leases, personal guarantees, particular property that might belong to one party or the other that the company's using. But if for example we set up a situation where there's a buyout in the case of a partner departing the company, either because they resigned or got fired, and we buy them out, that doesn't necessarily solve the problem that departing partner may have guaranteed a line of credit, a loan, a term loan, a lease. They may have guaranteed those things, and we can't just because they've left get rid of those obligations. We would need to go back to those parties, the bank, the landlord, to get those released, and that's not always possible. So sometimes these guaranteed obligations can be hanging out there. There are ways to solve those, but nonetheless, it's not always crystal clear and clean. The last point I wanted to bring up is just a special type of buyout, which is what we call a Texas shotgun buyout. And I think this really only works in a evenly divided partnership, 50-50, 49-51 sort of scenario where there's two parties. But the way it works is, often is the case with two partners who are of equal control. If a disagreement comes up and becomes fundamental and deteriorates their ability to work together, they might be looking for an exit from one another. And a Texas shotgun provision would give them the right, or at least one of them, well, give both of them, but one of them could exercise the right and say, hey, listen, I don't want to work with you anymore, so I'm exercising the Texas shotgun provision. So I called it. Now, and so the first partner usually picks the price and say, I think the company is worth X. Your 50% would be, 0.5X. And the other partner, the partner who did not exercise it, is usually the partner who gets to choose whether they buy or sell at that price. So theoretically, there's some incentive there for the person who initiates it to be fair and try to keep a price reasonable there, so that if they were forced to buy it at that price, they're not overpaying. And likewise, if they're forced to sell it, they're getting what they think is a fair price. So I think in practice, and this is probably one of the cons of this, is that it's I think that this sort of a provision lends itself to somebody who's got access to capital or maybe deeper pockets. Pros are, it's a way to get out of a 50-50 partnership, but it's really risky. I think in a lot of 50-50 partnerships, I think this, when we consult with partners about this, I think they adopt this as an option, maybe less than a quarter of the time. And they don't want something so drastic as, hey, I got to blow the company up and kick you out. And which means they have to kind of find other ways to work through problems. So that's really the land of buy-sell agreements in the partnership context. There's I think a lot of little details in each of those things, but that's kind of the high level framework and how we kind of consult with folks. If you or anybody, are entering into a partnership, multi-partner or whatever, you absolutely need to address these things up front and before you go into business with each other. Now, if you've already done it, if you've already started business, I always say the time to fix a leaking roof is when the sun is shining. So let's solve these problems, let's proactively address these issues before disputes arise, so that once a dispute has arisen, the chances of getting consensus or agreement on some of these points is near none. So then you're in a partnership dispute or divorce, and I can assure you that those are no fun. I would love to answer any questions that any of you have. But barring that, I really appreciate all of your time. We are at 12:30, but I will hang out for another minute or two if I see some questions. I don't see any at the moment, but if there are, please fire them in. And otherwise, I really appreciate it. Thank you so much for joining us today. And let us know if we can be of assistance to you or your team as you grow. All right, I don't see any questions, so I'll let you all go. Thanks so much.